Hey everybody, Sean Yesner here with Yesner Law. Continuing to talk to you about different blog posts that I've done. And so for those of you that haven't been watching, or maybe this is the first time you're watching, there's a video that I'm going to get up on the website on the Yesner Law Facebook page. And I think it was there, but it's only a minute for some reason, so I'm going to try to repost it. But it was about title issues raised by marital status. And then earlier in the week, I did another video about whether judgment liens can attach to inherited property. Well, another blog post that I have that seems to be generating a lot of questions from you all, from readers, is whether I can use power of attorney to sign company documents. And so I thought I'd take a few minutes and talk about that issue here on this live video. Can I use a power of attorney to sign company documents? And so here's the example. So if something happens to me personally, I can create a power of attorney and have anybody sign for me personally. My wife, my legal assistant, my parents, my sister, my associate attorney, whoever. I can create a power of attorney that says, hey, if I need to sign this deed, if I need to sign this mortgage, if I need to sign this document personally, my attorney, in fact, the person I give the power of attorney to, can sign for me individually. And so therefore I don't need to be there to sign. Now that document has separate requirements under Florida law, that power of attorney. It's not what this video is about, but basically it has to be signed with the formality of the document that is being signed. So if I gave my wife power of attorney to sign the deed because, let's say, for example, we were selling our house and I knew I was going to be out of town at the closing, and so I give my wife a power of attorney to sign the deed. Well, since the deed needs 2 witnesses and a notary, the power of attorney needs 2 witnesses and a notary. So it has to be signed with the same formality. But that's not what I'm talking about. Here's what I'm talking about. Same example. I'm going out of town, and I know that the business has some important document that needs to be signed, a deed, a lease, a vendor contract, whatever. Well, I am the sole owner of Yesner Law. I'm the manager of Yesner Law. I'm the president of Yesner Law. Yesner Law happens to be an LLC, a limited liability company. So can I give a power of attorney to my legal assistant or to my associate attorney to sign that corporate document, that company document, when I'm out of town and unable to sign? Or let's say something happens to me and I'm unable to sign, some medical issue or something. Can I give a power of attorney to my legal assistant, to my associate attorney, to you, to sign those company documents for me? Now, I said in this blog post that the answer is no, and I still believe that. I was challenged by one of my readers, to say, well, what's your legal basis for that conclusion? And I dug and I dug and I dug and I dug, and I couldn't come up with it. The best I could come up with at the time, and I've got the answer, and I'll give you the answer, but the best I could come up with at the time is, look, the company is its own entity. And so the company is saying, Sean as our president, Sean as our owner, Sean as our member manager, is allowed to sign documents for the entity. Now, Sean then can't delegate away that authority because the company may not have approved that third person. Now, in a small company like mine, may not make much of a difference, but when you look at bigger companies, yeah, directors sometimes get voted on, officers get appointed and voted on, and so, for example, I'm the president of my homeowners association. If something happened where I couldn't sign a document on behalf of the homeowners association, and I gave a power of attorney to you to sign that document for me, well, the homeowners association didn't elect you. The homeowners association elected me. So who am I to give that homeowner association authority to you? So power of attorney won't work, I don't believe, in that kind of a situation. Now, what will? A resolution. So the law firm, the homeowners association, the big company, Apple, whoever, could sign and create a company resolution that says, hey, while Sean is out, while Sean is incapacitated, we're going to make Joe Smith the person that has the ability to sign. And they do that by corporate resolution. In other words, the corporate resolution takes the place of the power of attorney. Now, like I said, somebody challenged me and said, well, what's your authority for that statement? And I dug and I dug and I dug, and I couldn't find anything. So if you have the legal analysis that provides that answer, absolutely, I'm happy to have it. But what I did do, I went back to my real estate documents. I went back to my real estate educational materials. And there's something in here that I want to read to you here real quick. And it is from the fund title notes. And it's basically what title agents use to govern how they issue documents, how they issue title insurance commitments, title insurance policies, those types of things. And here's what it says. Title examiners will, from time to time, be confronted with a power of attorney given by a corporation or a corporate officer. Of course, corporations may appoint agents under Florida statute. But in what form and manner does a corporation grant authority to its agents? Well, the board of directors must pass a resolution. A power of attorney is not the proper method. And then they cite some treatise. So again, not necessarily any kind of law, but makes sense. And think about it, not necessarily from the small firm format of my firm, but think about it more in terms of maybe the homeowner association that I'm currently president for. The voting members of my community voted for me to be on the board of directors, and the board of directors voted for me to be president. Well, if I give that authority to somebody else, I'm now outside of the vote of the voting members and the board of directors who have elected me president. Now, again, that doesn't mean I can't delegate that away, that authority temporarily. One thing the association could do is sign a resolution that says, temporarily, we're giving Joe Smith all the authority of Sean as president. Now, I doubt they would do that. Probably what would happen is the vice president would make decisions. It would still be a 6-member board, so they would still have the authority to make decisions. So that's probably not the way it would work, but I think under Florida law, that's one way it could work, is you appoint. And so let's bring it back maybe to my small business. If I knew something were going to happen where I was going to be out of the office, maybe some kind of surgery, maybe some kind of, whatever, I could sign a resolution that says my associate attorney can sign documents on my behalf. And that would be the proper way to do it, not to make her the power of attorney for me in my corporate company LLC capacity. That's not the way to do it. So if you have questions, let me know. Certainly reach out. You can contact me here on Facebook. I'm happy to answer questions that you have. If you're watching this on some other social media channel, Instagram, YouTube, whatever, and you want to contact me there, feel free to contact me there. But if you have questions about, something's going to happen and I need to figure out what's going to happen with my corporate authority, give me a buzz. Let's figure it out. There's a ton of different ways we can skin that cat, but one of those ways is not with a power of attorney. I do also, before I go, want to promote my latest book, Become Debt Free, which you can find at SeanMYesner.com/become debt free. You can pick up the book there. Otherwise, thank you for watching this short video. If you have any questions, connect with me. Otherwise, I'll see you in the next video.